Hi everybody, I'm Kari Simpson and this is Culture Guard. We're starting a series and many of you know the roadkill radio universe out there, that we have a particular attention that we're making known, I guess, in no uncertain terms, our concern about what's happening within the courts, the administration of justice in Canada. And we're adding our voices to those that have already been sounding off, because there's been a lot of sound off of late, about judicial activism. The proper role of judges in our democracy. Are they overstepping their bounds? Are they getting involved in areas that should be left to our parliamentarians, for instance? We're also concerned about the lack of accountability within the judiciary. And today and on the next show, we're going to pay particular attention to this aspect of our concern. And that is, what happens when judges go bad, do things that are wrong? Can Canadians have confidence in the processes that are currently set before us, the Canadian Judicial Council, for instance? Can we trust these judges to judge other judges? What has happened in the past? What's going to happen in the future? How do these processes work? And we as Canadians, should we be looking at maybe revamping the system, I think? Joining us today is an Ontario lawyer, Christopher Taucar, and Christopher is a published author. He's got a lot to say on this matter, and he's one of the brave Canadian lawyers who is willing to go public with his concerns. And we're going to talk about some of the cases that are at the forefront of his concerns at this point, including complaints to the Canadian Judicial Council. But before we get into the details involved in those complaints, we're going to talk broadly about what's happening, what's transpiring in the courts and across this land right now. Christopher, thank you so much for joining us here on Culture Guard.
It's my pleasure to be here.
Now, you practice in Ontario. You're a practicing lawyer. You're a published author. What interests you so much that you take the time to write books about these subject matters?
Well, I do academics, and I also teach part-time at university, so these kind of issues are quite natural to me. And although my practice is fairly broad-range, it deals with administrative law, litigation, but my research is really in the area of the Constitution, judges as decision makers, and courts as institutional bodies. So this actually fits all within my main interest.
Now, I started the show off by saying that there's growing concern. Is that something you're witnessing firsthand from being a practicing lawyer and involved on a daily basis in the area of law?
Yes. I can say that there won't be, you're going to have difficulty getting lawyers actually to talk about this, but I know I talk at least to conservative lawyers, and they're very worried about the judicial activism aspects of the issues that we're talking about. The case that I'm actually going to be talking about today goes actually well beyond that, and we're talking about complaints of misconduct, going well beyond activism and judges making up things that aren't in the law.
Well, and that is a part to what's going on as far as accountability goes. And that umbrella of accountability spreads both to the judicial activism, whether judges are acting within the boundaries of their purpose. And if judges can be allowed to act outside those boundaries, then what the heck? We might as well just ignore the corruption within the courts and some of the areas that should be of concern to our politicians as well. Now, I want to just pick up on a comment that you made about getting other lawyers. You are so right on that, because lawyers call me and write to me and they send me all kinds of information all the time. But there is this understanding within the profession that if you speak out on these issues, if you break that wagon of circles, or that circle of wagons, you stand to lose big time as far as a career and a profession goes. Is that a legitimate fear?
Oh, yes. Just think about this, just the incentives of this. Judges talk to each other. They talk about lawyers. Now, you come from a litigation firm who appears before judges who have, let's say, been critical towards judges or have uncovered things that shouldn't have happened. it's very easy for you to be punished before the courts.
And that can come down in a variety of ways. You just aren't going to find judicial favor in the cases. Your clients are going to pay the price. You're going to be blocked with legal procedures. There's a number of tools that are available to those sitting on the bench to discipline you with. Am I right in that?
Well, that's right. And I think what concerns us is that I don't think this ever was as great in the past, although I'm sure it did occur, is that more and more judges are thinking themselves entitled to decide who they want to win first. And then finding laws or ignoring arguments that they can't deal with, or even worse, making findings of facts that support their position, rather than just acting in accordance of law and the law of evidence.
Okay, let's talk about this in two separate categories then, and let's touch a little bit on the activism of the courts. Ever since Trudeau brought in the Constitution, there seems to have been a certain amount of liberty taken in the interpretation of what the Supreme Court of Canada and the courts should be doing. And it's not necessarily constitutionally relevant. It seems to be more relevant to where they view their core values or where they believe society, a Canadian society, should be going, regardless of democracy, regardless of the law, regardless of community values. There seems to be a we know better attitude, so we're going to make this ruling. We are going to read into law. We're going to read down law. We're going to ignore law. Is that, am I being outrageous in that statement, or is in fact this what's happening in some of our courts?
Well, I think that is what's happening. And one thing I might want to put or mention is that when the Charter first came in, you had the Liberals in power. And Trudeau intentionally stacked the court with people who would think according to his views. And you've had decades and decades of Liberal governments appointing Liberal judges. And I can tell you the very first decisions that came out on the Charter, they were quite conservative until they got to the Supreme Court. Now you can't get conservative decisions anymore.
Well, and I don't even care whether they're conservative or liberal as long as they're constitutional. That's my concern. When I've studied these cases that have gone before the Supreme Court, the politics of the day, yay or nay, shouldn't be the factors. It should be whether or not it's constitutional relevancy or whether it's the letter of the law. This business about changing the law or interpreting the law in a way that's convenient to the political activism, and I believe, is it Ted Morton who referred to the activism of the court as the court party?
Right. And those are all the people who are around it, who are making a lot, the activist groups who are using the courts to attempt to push their agendas through when the legislatures won't act on it.
Yeah, and actually you're opening up a whole nother subject matter, because in fact that's what's happening. When democracy won't serve the needs of these well-funded special interest groups who typically are getting government money, they go crying to the courts. The court then just ignores the law, and I can think of at least 2 or 3 cases where this has happened. And they read into law or they read down the law. When I read the case involving the judge where they were going to read down the law, that was a new one for me. But they read into law their own interpretation, or they expand a definition, or in some cases they'll modify the law and just change it up to whatever's convenient to fit their agenda and their result that they have chosen to benefit this party with.
That's right, and to some extent, judges always bring their own biases and views to interpretation. To some extent, there's legitimacy in that, but we're talking about going well beyond that. And when I say conservative, I didn't mean political conservative. As a conservative jurist, for example, when you interpret parliamentary legislation, you ought to be interpreting what Parliament intended and not what your purpose for that legislation is, or what you'd like to see. Good
clarification. Okay, now the culprit in many of these cases that so many books have been written by, we've got Philip Slayton, Mighty Judgment. We've got a number of books that have come out that are starting to address the growing recognized problem. It's just not a problem. This is based in fact. We have a problem in Canada with activist judges. Now, the Supreme Court of Canada has been identified as one of the big culprits in this case. Now, what form of accountability is there to the Canadian public to ensure that the Supreme Court of Canada acts accordingly to within the boundaries and purviews that it exists? Is there anybody overseeing the Supreme Court of Canada that can spank them, for instance?
Okay, well, there's a standard answer, and then there's one that really answers your question. The standard answer is, well, there are some people watching, there are lawyers who are watching, there's academics who are watching, except the problem in the academic case is that they're more usually liberal and hard leftist than the judges, and they're the ones who are pushing judges to do more. But judges are accountable in the sense that they have to follow precedents, and they might be subject to criticism. But the real difficulty is Parliament is not really, and Canadians are not really watching what judges are doing. Parliament has jurisdiction under Section 33, for example, to override judicial decisions. That is, judicial decisions they think are not proper under the Constitution. And this is a power that Parliament's had for over 1,000 years. I'm just finishing a book on the British system of government in court jurisdiction, and it was always well recognized that Parliament can very well overrule judges, and their decision was much higher and taken with greater dignity.
Now, a lot of my research of late, because of the decision for this media organization called Roadkill Radio to travel down this road, has included reviewing a number of the speeches given by various judges, with a lot of attention to that of the Chief Justice Beverly McLaughlin. Now, there seems to be an undue amount of attention being played to promoting the idea of judicial independence. Now, I mean, the language of "thou protestest too much" comes up because this seems to be an ongoing song being sung by a number of judges, and they're concerned that somebody's going to reel them in here. Is there growing tension, do you believe, among the legal community that is suggesting that judges are fearing the fact that maybe they've overstepped their bounds, and that Parliament will actually act and start bringing them back to their proper role within our civil democracy?
Well, you have to understand how judges are organized. They have a kind of union, and they've been pushing greater and greater independence for themselves, notwithstanding the fact that they have tenure during good behavior, and Parliament sets their salary. Now, this was good enough independence since the Act of Settlement of 1701, and judges haven't been interfered with. But suddenly, they wanted more and more independence. And what they actually did was something quite illegal. They used unwritten constitutional principles to invent judicial compensation committees, and they have absolutely no authority to do that.
Okay, so you're just opening up the hornet's nest here on their show 9 and 10 that we need to do, Christopher. Okay, so we're seeing not just within the decisions of the courts, but in the administration of how our courts are run, that they're running amok in those areas as well.
Well, administration and court, I have actually in part of my case, we're not going to get into, we found that there were some administrators doing some bizarre things, covering up for that was prejudicing my client and kind of covering up for a judicial spouse. But when we're saying administrative of the courts, that's how courts are administered. But we're talking about associations of judges and how judges continually sued the government and they were making decisions upon their own salaries. I think that's more judicial politics, we'd call that, rather than judicial administration.
Okay, so we're going to try to be educational in this because, and bear with me, I apologize, because there's so many facets to how our courts are run. I have to be honest with you, I have become overwhelmingly shocked, if that's possible, at how many various associations there are that cater to judges and lawyers and all kinds of different little committees on this and that. There's a lot going on behind the scenes as far as the administration of justice in Canada goes. And as you say, you know, these little union sort of organizations, they're spread out right across Canada.
Yeah, every level of court, every level of judges have their, I call them a union, they call them judicial associations, and they look after their own interests politically.
And those interests don't always include Canadian interests. We're interviewing Christopher Taucar, and he is an Ontario lawyer, a published author, and one of the lawyers who cares enough about the integrity of our judicial system to stand up and lend his voice to bringing understanding to you, the people, about what is going on in our courts. As I travel this country, increasingly people are talking about the courts, what's going on in the courts. We're seeing decisions that shouldn't be being made, that they're overstepping into areas that Parliament should be addressing. And increasingly Canadians are saying enough is enough, the nonsense has to stop. Mr. Taucar, let's talk a little bit now. We know we've sort of covered the activism aspects of the court. What about the Canadian Judicial Council? What happens if a judge just makes a bizarre ruling, has an outburst in court, which is something that's happened recently, is involved in pornographic depictions on the internet, courtesy of her lawyer spouse? What organizing body has the lawful right to investigate complaints about judges?
Right. So the Canadian Judicial Council investigates complaints about federally appointed judges. So those would be the Superior Court judges. There's also a council for the provincial ones. And so what they would be looking at is that they'll be asking the question, is this a question where the judge was wrong in their opinion? And if it was wrong, then they'll say, well, this is a matter for appeal. But if it's a matter of conduct where it really brings the administration of justice into disrepute, where people can't have confidence in the judiciary because of this kind of misconduct, contrary to the Judges Act, then the Judicial Council has the authority to investigate, and then you get a minority of these judges who make an initial investigation. If they find misconduct under the Judges Act, then it'll go to the entire Judicial Council, and what they can do is then recommend removal from office.
Now, the way that the Canadian Judicial Council is structured, Chief Justice McLaughlin is assigned as chairperson to this council. That's in the Judges Act, that's the requirement. The Chief Justices of the various province also have a prominent role in making up the council. Are there other judges involved in the makeup of the Canadian Judicial Council?
I know you've got them right. You've got the Chief Justices and Associate Chief Justices, and I don't know if there's I have a list of them, and I don't have one off the top of it.
Actually, it was the Associate Chief Justices that I neglected, because I know the Chief Justices are also included, the Associate Chief Justices.
Now, I'm just wondering if there are a smattering of other judges, and there could be, and I'd have to just look that up for you.
Okay, now, when we get to an area of conduct, because as you say, if you have a problem with the decision, the law of a decision, that the route for that disagreement is through the appeal process. If it gets up to the Supreme Court of Canada, barring the parliamentarians, acting in some leadership capacity, if it's that egregious of error, under Section 33, you're stuck with the decision from the Supreme Court of Canada. Now, the decisions of the Canadian Judicial Council then deal with conduct. Now, under the Constitution Act, judges are required to be of good behavior. That means in and out of the courtroom, does it not?
Yes. Yes and no. If this conduct outside of, or inside or outside of court would have the effect that it would be perceived that this judge has now lost the integrity or has lost the public's confidence in the judiciary, then it could be a matter of discipline.
Okay, now let's look at that as far as conduct goes. What about then when we see judges operating unconstitutionally, or for instance reading into law, and operating, their conduct then extends beyond what they have legal authority to do? Is that something that the Canadian Judicial Council would look at?
No, they wouldn't take that position. They would say that that's an error of law.
Okay, so they'd say, sorry, too late, no good, we can't deal with that. That's not within our realm of decision making here then.
Unless the judge you can demonstrate acted not honestly. He didn't or she didn't honestly believe in the correctness of his or her decision, then that would be a conduct issue.
Okay, so honesty of belief then. And what test would they use? The one that's been assigned, for instance, in defamation cases?
I don't think it's ever come up. And now my complaint has an aspect of honesty of belief, because in our complaint we said, based on this other judge's decision, he couldn't possibly have believed what he was saying.
Okay,
but that's never actually been decided, to my knowledge, before the Canadian Judicial Council. So we don't know exactly what they're going to say.
So you're trailblazing here, are you?
Yeah.
Okay. Christopher Taucar, thank you so much for joining us today. We will come back on the next show for Culture Guard. We're going to have Christopher back, and we're going to get into some specific complaints. We're going to look at a case that he is very involved with. The judicial shenanigans in this, the corruption of the process will it shock you? Do we Canadians get shocked anymore? Well, if anything, I hope it makes you righteously indignant and motivates you to become involved in probably one of the most important issues that Canadians face right now, and that is upholding the rule of law in Canada. Without the rule of law is a cornerstone. It is the soul of this society, people. We need to protect that. It is the decision making between what's right, what's wrong, what's good, what's evil. And when we lose our grounds on this front, we've lost our democracy. So we need to be involved. We need to be informed. We need to understand these issues. And Mr. Taucar, I am very thankful on behalf of a number of Canadians for your integrity and courage in bringing to light these important matters for us.
Well, thank you for having me on.
All right, everybody, I'm Kari Simpson, and this is Culture Guard. Good night.